Today, we're looking at two big legal stories that at first glance seem to pull in opposite directions. One involves immigration, where the Supreme Court just greenlit a sweeping federal action removing about 500,000 people. The other involves trade tariffs, where a federal court slammed the brakes on the president's sweeping use of emergency powers. It's a bit of a paradox. In one case, the government's power appears almost unlimited, and in the other, power is sharply checked. Let's break down both cases and see what they tell us about constitutional law. Our first story comes from the U.S. Supreme Court. Picture this: nearly 500,000 immigrants, many from Cuba, Haiti, Nicaragua, and Venezuela, who fled turmoil in their home countries, had been allowed to live and work in the U.S. under a special humanitarian program. This program, created during the prior administration, granted them parole status, basically a temporary permission to stay for up to 2 years on humanitarian grounds. They passed background checks, had U.S. sponsors. It was all part of a plan to discourage illegal border crossings by offering a lawful pathway. Entered the new administration. Shortly after President Donald Trump's second inauguration, his DHS secretary, Noem, moved to terminate these parole programs entirely, all at once. Overnight, the legal status of those 500,000 immigrants was set to be revoked. A federal judge in Massachusetts cried foul and blocked the blanket termination, ruling that the government must at least assess each case individually rather than yanking everyone's status in one go. That seemed like a basic rule of law check. You can't just upend 500,000 lives without some due process. But just last week, the Supreme Court stepped in on its emergency docket and overrode that injunction. In a brief unsigned order, the court allowed the administration to go ahead and end the program immediately while the legal battle continues. No detailed reasoning from the majority, just a one-paragraph order. However, two justices, Sotomayor and Jackson, dissented loudly. Justice Jackson wrote a stinging dissent, accusing the court of having plainly botched its handling of the case. She warned of devastating consequences for the immigrants who had structured their lives around this humanitarian protection. In essence, she argued that even if the government might ultimately win the case, there was no urgent reason to drop the hammer right now, while appeals were pending. So why did the majority of the court allow the government to proceed? Although they didn't spell it out, legal experts widely believe it comes down to the plenary power doctrine in immigration law. It's a dramatically important doctrine to understand, and one which most commentators miss or sometimes decide to ignore. I've covered it in a few past videos where I correctly predicted the results of a few challenges to Trump's deportation powers, and I'll drop a link in below. Under long-standing Supreme Court precedent, Congress, and by extension the executive, has plenary power over immigration, basically almost complete authority to decide who can enter, who can stay in this country. The doctrine dates back to the 19th century Chinese exclusion case and other decisions, and it's still very much alive. In plain English, immigration is one area where the normal limits on government power are exceptionally relaxed. Policies that would never fly in other fields can be lawful in immigration because they're seen as tied to national sovereignty. The court has said that shaping immigration policy is an exclusively political function of the elected branches, not the judiciary. Now, if you listen to some commentators, even ones I've watched in the past, you'd think this doctrine doesn't exist. But for serious legal commentators and scholars, it's not a debatable point. Here, the law at issue, the Immigration and Nationality Act, explicitly gives the Homeland Security Secretary broad discretion to grant or revoke parole as she sees fit. In fact, the Trump administration's brief pointed out that the federal law even says no court shall have jurisdiction to review certain immigration decisions by DHS. The majority of justices presumably found this argument convincing. If the statute and over 100 years of precedent say immigration decisions are largely beyond judicial second-guessing, then the Supreme Court wasn't inclined to stand in the way. Now, for those of us who believe in limited government, it's a bit jarring. Normally, conservatives and libertarians cheer when courts constrain the heavy hand of government. But immigration has always been the exception to this rule. The plenary power doctrine basically gives Uncle Sam a blank check at the border, a degree of power that would be unthinkable in almost any other context. As a result, a policy decision many might view as overly broad or harsh, canceling a humanitarian program en masse, is likely perfectly legal here. Now, it doesn't mean the policy is above criticism. Even limited government proponents might ask, just because the feds can do this, should they? Justice Jackson's dissent certainly suggests not, highlighting the human cost and lack of immediate necessity. But in terms of legal authority, the majority is treating this as business as usual for immigration, a realm where, like it or not, the government's power to act is at its broadest. If you're listening to any of the popular legal podcasters and they ignore this bedrock, century-old principle, they're not telling you the whole truth. This doctrine is a stark reminder that our system makes immigration a special case, where liberty and limited government take a backseat to sovereign power. But once we get out of this exceptional and limited area, those rules change, and that explains Trump's recent tariff loss in court. Let's flip to the second story, which comes from a very different court and paints a very different picture of presidential power. While the Supreme Court was effectively giving deference to broad immigration powers, the U.S. Court of International Trade was busy telling the president, not so fast on another front. Here's the background. Earlier this year, President Trump announced sweeping new tariffs on imports from almost every country. He did this by declaring a national emergency under a 1977 law, the International Emergency Economic Powers Act. The administration dubbed one set of these duties the Liberation Day tariffs, ostensibly to celebrate America's liberation from unfair trade. In practical terms, the plan was to slap a 10% tariff on all imports across the board and even steeper rates on goods from countries with big trade surpluses against the U.S., like China. Some tariffs on Chinese products were set to spike astronomically. We're talking total rates up to 145% in certain cases. It was a shock and awe tariff strategy aimed at forcing trading partners to the negotiating table. For many small American businesses, it was terrifying. Think of importers, retailers, niche manufacturers. They suddenly face ruinous costs. In fact, the first lawsuit against these tariffs wasn't brought by some giant corporation or ideological opponents of Trump. It was led by 5 small businesses and a 42-year-old entrepreneur in Florida. These entrepreneurs, represented by the Liberty Justice Center, essentially said, hey, we believe in fair trade, but this is way beyond the president's authority and it's going to kill our businesses. And guess what? They won, at least this round. On May 28th, a 3-judge panel of the Court of International Trade unanimously blocked most of Trump's new tariffs from taking effect. The ruling was pretty blunt about presidential overreach. The court held that the U.S. Constitution gives Congress, not the president, the exclusive power to regulate international commerce. And that power isn't overridden just because the president says the words emergency. In other words, you can't use a statute like this as a blank check to usurp Congress's role in setting tariff policy. Let me pause here for just a minute because it drives me crazy every time I make the mistake of scrolling through social media to see what people are saying about this ruling. Instead of engaging with the real issues, the detailed facts, the constitutional principles at stake, they resort to lazy accusations and absurd conspiracy theories. People are calling Judge villains, puppets secretly controlled by George Soros, or pawns in some shadowy plot. Let's get real. The judges deciding this case were appointed by Ronald Reagan, Barack Obama, and yes, even Donald Trump himself. That's about as bipartisan as it gets. Hardly a recipe for some conspiratorial deep state coup. Critique the arguments, sure, but spinning conspiracies? It's intellectual laziness and it's beneath serious discussion of important legal principles. Back to our case. The judges issued a permanent injunction stopping all the broad tariff orders Trump had issued under the law since January. They made it clear that it wasn't about whether the tariffs were a good idea or not. In fact, they explicitly said, do not pass upon the wisdom or effectiveness of Trump's trade goals. The point was that the law simply does not allow it. If the president wants to remake the tariff landscape, he must get approval from Congress. A key issue was the definition in the case of emergency. The law was meant to let a president respond to unusual, extraordinary threats to national security or the economy. Think hostile actions by foreign powers, global crises, and the like. President Trump's justification here was the trade deficit, something that has persisted for decades. The court was not convinced that this long-standing economic situation qualified as an emergency in a legal sense. Chronic trade imbalances do not amount to the kind of unusual and extraordinary threat that the law required. This ruling, I think, is a big win for the principle of limited government. It's court saying, even if your intentions are good, you don't get to sidestep the Constitution or Congress by declaring an emergency that isn't real. In short, the courts reminded everyone that in America, major economic decisions like taxation and tariffs aren't up to one person. It's worth noting that the Justice Department quickly filed an appeal, and there may be more legal wrangling to come. In fact, the administration reportedly argued that the court shouldn't second-guess the president on a national emergency declaration, an argument that we saw in the immigration case can sometimes prevail. But for now, the tariff block stands, and it sends a strong message. The founding principle of no taxation without representation got some courtroom love here. Tariffs, after all, are taxes on Americans buying goods. The Court of International Trade said, if you're going to tax the American people with import duties, you need Congress on board. The president cannot unilaterally act as tax collector-in-chief unless there's a genuine emergency with clear statutory authority. So what do these two legal battles tell us when we put them side by side? They highlight a fascinating contrast in how our system allocates power. On one hand, in the realm of immigration, the federal government often gets wide berth, so wide that a single executive decision can impact hundreds of thousands of lives, with courts largely hands-off due to doctrines like plenary power. On the other hand, in areas like economic policy, the default expectation is quite the opposite. The tariff case shows that outside of immigration, the courts and the Constitution will zealously guard against one branch accumulating too much power. Emergency powers are not a magic wand. If a president tries to use them to do an end run around Congress for something like nationwide tariff policy, the judiciary is ready to step in. In most policy arenas, our system demands on checks, balances, and genuine justifications for extraordinary action. Because I tackled two issues, one favoring the Trump administration and one against, I'm bound to get plenty of heat and haters in the comments. But folks, this channel isn't about cheering a political tribe or feeding partisan outrage. There's already more than enough political junk commentary out there. My goal is serious constitutional analysis and thoughtful discussion. It's genuinely disappointing to see otherwise intelligent legal scholars conveniently ignore something as fundamental as the plenary power doctrine just to paint Trump as a fascist over immigration. That's intellectually dishonest. And yes, it's also troubling when tried and true conservatives cheer a president, any president, pushing the further boundaries of executive power. We can do better. And that's what this channel aims to offer, legal analysis that's clear, true, and more useful than what you typically find. If you value deeper insight instead of superficial shouting, you're in the right place. That's all for this update today. 2 court cases, 1 big lesson about limited government with an intriguing twist. Thanks for watching, and please don't forget to like and subscribe. It helps me grow this educational project. Be sure to join us next week as we dive into yet another fascinating constitutional controversy.